Yes.
Great.
Yes.
Okay, great. Well, thank you everyone and welcome to our session this morning. This is self-advocacy in the workplace, know your rights. My name is Denise Lugo Fowler and I am the Director of Outreach for Disability Rights New Jersey. And just going over a few quick housekeeping items. If everyone can mute their microphones, we can just limit the distractions during the session. If anyone needs captions, they are available. Just click on the CC button, live transcript at the very bottom of the Zoom menu, and that will bring them up for you. Also, if you have any technical issues, please put them in the chat box and I will be happy to address those with everyone or for anyone that has any. And please, we encourage everyone to comment, add questions. You know, we want this to be an interactive session, so please feel free to, put questions in the chat box, unmute yourself during the panel. And, we want to share information with everyone who's here. So with that, I welcome our panelists, Susan Head, who is a senior staff advocate, and Charles Auslander, a senior staff attorney for Disability Rights New Jersey. And with that, I turn it over to our two panelists. Thank you.
Thank you, Denise. Hi, everyone. My name is Charles Auslander. I'm a staff attorney here at Disability Rights New Jersey. First, I want to thank everyone for sharing this part of your morning with us regarding this session on Know Your Rights. It's a session about reasonable accommodations in the workplace for those persons who may have disabilities. So welcome, and joining me is my colleague Susan Head, who's a senior advocate here at Disability Rights New Jersey. This session, like the other ones that we've had, we want it to be a roundtable. We don't want it just to be us providing information and you sitting and listening to that information. We are going to do that, but we'd really prefer that if you have questions at any time, if I'm using maybe a PowerPoint slide or I'm describing something, feel free to stop and either unmute yourself, because I'm sure that Denise will provide you with that option, and ask a question. Or if you don't want to do that, raise your hand, and then I can call on you individually so you don't have to necessarily interrupt me by taking yourself off mute. Or you can put a question in the chat box and either I or Susan will stop and we'll try to answer that question. The reason I mentioned this at the outset is we want this to be a genuine roundtable where people ask us questions and we have a discussion about reasonable accommodations, what they are, how to obtain them, and for what purposes. So I will start off by giving a presentation and talking about the law surrounding reasonable accommodations. And in addition, I'll talk about the actual practical steps about how to request and obtain one. But I really strongly encourage everyone to think of questions and don't be shy about asking them. Again, whether you unmute, whether you raise your hand, whether you put it in the chat box, the more questions, the better. I don't have to reach the end of my presentation. Susan and I are here to provide you with information to help you, as opposed to us just going through the information that we prepared today. So with that, I am going to share my screen with you just for a few slides. And the slide you're going to see up front right now is learning objectives. And the reason I put that up there is I wanted to give you an idea of what I'm going to be speaking about. And then I'll break it down into a little bit more detail. But again, at any time that you want, please ask questions. That's what we're here for. So know your rights, reasonable accommodations in the workplace. Reasonable accommodations are provided to people who have disabilities in order for them to be able to do their jobs, just like individuals who may not have disabilities that impede their ability to work. And the law that provides the right to have reasonable accommodations comes from several sources. The first is the ADA, that's the Americans with Disabilities Act. That's a federal law. It's a very long and big federal law, and it covers many things in terms of anti-discrimination provisions. But one of those anti-discrimination provisions is reasonable accommodations. The next law we'll be talking about is our state law, the New Jersey Law Against Discrimination, sometimes known by its acronym LAD, L-A-D. So just like the ADA, the Americans with Disability Act has an acronym, so does New Jersey. New Jersey's LAD, or Law Against Discrimination, is actually a lot broader and more beneficial to employees who may have disabilities and those employees seeking reasonable accommodations. We'll also talk about how you request a reasonable accommodation from your employer and what information you may need to disclose about your medical condition or disability. Now, as I just mentioned, the Americans with Disabilities Act is a federal piece of legislation. I apologize. Is a federal piece of legislation that covers many things, but one of the things it covers is reasonable work accommodations for what are called qualified persons with a disability. And qualified persons with a disability has its own definition. It'd be those people who are eligible or subject to requesting a reasonable accommodation. Well, what rights do you have under the Americans with Disabilities Act? Well, you can't be discriminated against if you're seeking a reasonable accommodation, but you first have to be a qualified individual. This applies to circumstances like job applications, hiring, advancement, if you're terminated because you're having accommodation, training, promotions, employee compensation, essentially any of the terms and conditions of employment, both as you're seeking a job with an employer, during the interview process, accommodations can be requested. And then once you actually are offered a position and have employment, at each stage, you can ask for an accommodation. Now, it may be that you don't have a disability when you applied for and interviewed for a job. You then have the job, you're working at it for a number of years, and you acquire a disability. Well, that would be an instance where you ask for it after the fact, since you've already been hired and you're working there. What's a qualified person under the ADA? A qualified person is someone who has a disability. That would include a developmental disability or an intellectual disability. And that individual, with or without a reasonable accommodation, and we'll talk about those in a little more detail, can perform the essential functions of their job. The reason that word or phrase rather is emboldened, essential functions, is that you still have to be able to do the job. The whole point of a reasonable accommodation is that if you're provided with an opportunity to have, say, for example, different terms and conditions of your employment or access to assistive technology, things that let you do the job, as long as you can perform the same job as other individuals who may be non-disabled, if we provide you with those accommodations and you do those essential functions, you can't be terminated, you can't be discriminated against just because you need that extra assistance. What are essential functions? Well, I've just alluded to that. Those are the basic job duties that you as an employee must be able to perform. And it's very fact dependent. A lot of times when people ask advice from attorneys, they often hear the phrase, it depends. Well, it does depend. It depends on the facts of your case. What are the basic job duties for your position? What are those essential functions? What's the nature of the accommodation you're seeking? And what are your functional limitations based on your medical condition or the disability that you're requesting an accommodation for? Now, as I said earlier, the Americans with Disabilities Act is a lot narrower than the New Jersey law against discrimination. I'll flip it and say it in the reverse way. The New Jersey law against discrimination is broader than the Americans with Disabilities Act. Here's why. In order to be covered under the Americans with Disabilities Act, you have to be an individual with a physical or mental impairment that substantially limits a major life activity. That also has a definition under the law. The New Jersey law against discrimination doesn't have that particular definition, so LAD is broader than the ADA. You can also have a history or a record of an impairment, or you can be perceived by someone as having an impairment. Those same two other bullet points, those requirements, also exist under the New Jersey law against discrimination. Now, this is just really a long list of what are major life activities, and it's essentially being alive and being a human being, caring for yourself, performing manual tasks, eating, hearing, sleeping, speaking, reading, concentrating. Basically, anything you're doing as a person would be a major life activity. And if you're going to need an accommodation because of an impairment from one of these activities, You then have to look at what your job duties are and whether you're able to do them if your employer provides an accommodation to you. And again, it's got to be a reasonable one. I'm going to skip ahead. Who does the ADA apply to? Does it apply to all employers? No, this is another limitation compared to New Jersey's law against discrimination. It applies to employers that have 15 or more employees. It applies to private employers. In a different part of the law, it applies to both state and local government and also the federal government. But they have the Rehabilitation Act of 1973. The federal government still has to abide by these rules, but it's in a different part of the law that I just mentioned, but it's substantially similar to the ADA. Now, the law against discrimination, also known as LAD, that's the acronym, it provides more protection to more people than the ADA. That's that theme I've mentioned earlier. And under the LAD, disability has a much broader definition. As you can see here, it's any physical or sensory disability, infirmity, malformation, or disfigurement. And then it goes on, that ellipsis goes on to all these different physical and mental impairments you might have, which prevents the typical exercise of any bodily or mentally functions or is demonstrably medically or psychologically by scientific standards existent or provable. So basically, if you have any sort of infirmity, physical or mental, that can be demonstrated to be a medical condition or an impairment, you might be eligible for a reasonable accommodation under New Jersey's law against discrimination. It doesn't involve an impairment of a major life activity. So that's another example where the New Jersey LAD or any discrimination law that provides for reasonable accommodations is a little broader. Now, I've been talking for about maybe 15 minutes, which is kind of a long time. Does anyone have any questions thus far about what reasonable accommodations are and the two major laws that would apply if you're seeking one here in the state of New Jersey? Please don't be shy. This is not a part of the law that's easy to understand, and many people don't know their rights, which is why we're here today, to sensitize you to the rights you might have if you have a medical condition or a disability that impairs your ability to do your job. So do we have any questions in the chat box? No questions? Okay. The reason I mentioned, for example, an acquired disability, I'm going to go off on a bit of a tangent, is that some people have disabilities from birth. They're congenital. Some might develop them later on in life. And I've had clients that acquired disabilities, maybe like multiple sclerosis or something else, while they have an employer. And they're working and they start having issues. Maybe they start tripping, they start having tremors or some other neurological symptoms of their diagnosis. And those people tend to say to themselves, okay, maybe they're in a little bit of a denial or concerned. I don't want to tell my employer because I'm frightened of losing my job. And as we go on in this presentation, I want to strongly advise people, if they do have a diagnosis, if they do have a disability or a medical condition that starts affecting their work, you're eventually going to have to disclose something to your employer. And the reason I say that is if your employer doesn't have notice and they decide, gee, you're not able to do your job, they don't know why, they just notice that you're not performing as well as you used to, maybe you're not meeting certain metrics your employer has set for you, and then you're put on a performance improvement plan or maybe even terminated. If you don't tell your employer you're struggling and the struggle is because of a medical condition or disability, they're not going to have the opportunity to engage in what's called an interactive process, which I'm going to talk about in a little bit. So there comes a point where you may have to tell your employer about a condition if it's acquired, as opposed to someone who their disability or condition may be manifest. For example, if someone had cerebral palsy and they ambulate in a wheelchair, that would be pretty evident to most people, well, this person has some sort of condition or disability. They may not know it's cerebral palsy, but you're ambulating in a wheelchair and there must be a reason for that. So I'm going to go on with the presentation with the proviso that if anyone has questions, please ask them, chat, raise your hand. It's all okay. So as I just mentioned, the New Jersey law against discrimination does not require a major life activity impairment, which means it's broader in scope and coverage. So if you're living or working in New Jersey, you'll be eligible to invoke the law against discrimination. I'm just going to take a drink here for a moment. Now, the next question is, how can I find out if my employer must follow the law against discrimination? Well, unlike the ADA that requires or covers employers with 15 or more employees, the New Jersey law against discrimination applies to companies with at least one employees. Well, what that means, ladies and gentlemen, is it's much broader. And obviously, if you're working for someone, you could be that one employee. Where is it similar with the ADA, that is the law against discrimination? You still have to meet your job qualifications and perform your essential job functions. And you can ask for a reasonable accommodation if you're provided with it, it allows you to perform your tasks or apply for a job and interview like someone else who doesn't have a disability or a medical condition. So I'm going to talk some more about reasonable accommodations now, but I want you to understand, if you're working in New Jersey, or if you live elsewhere, but you still work in New Jersey, you're likely covered under the New Jersey law against discrimination. And as I indicated, it's probably the more beneficial law to request your accommodation under, but you don't necessarily have to specifically say I'm covered under the ADA or LAD. You're just asking for a reasonable accommodation. I'm going to go through this one example. Well, I'm going to skip the example because I want to hear questions from people. What are reasonable accommodations? Well, basically, it's any modification or change to either the application or hiring process or your job that allows a person with a disability who's otherwise qualified to perform the essential functions of that position. I've mentioned that probably about 2 or 3 times now. It's really important to understand that. If you can't do a job, even with an accommodation, you can't perform those essential job functions, which tends to be a fact-sensitive question, as I mentioned earlier, then it's simply not going to work. And one of the reasons is that employers don't have to provide reasonable accommodations if, despite doing so, you cannot perform the essential functions of your job, or it presents an undue hardship to the employer. And we'll talk about that in a moment. But I did want to focus on what a reasonable accommodation is, because the crux is that those people who have a medical condition or disability, as long as they're given the appropriate, reasonable assistance and accommodations, if they're able to do their job, they should be able to do their job. And an employer can either terminate them or switch them around to some other position that they weren't doing in the past. Now, there's an acronym that we've used for requesting reasonable accommodations. I'm going to stop right now and mention that when you make a request for a reasonable accommodation, in the biggest picture, so it doesn't seem as technical, what it's about is working it out. It's putting your employer on notice that you're having difficulty doing your essential job functions because of a medical condition or disability, putting them on notice, making a request that you have an accommodation so you can adapt to whatever functional limitations you have in doing your job. The employer and you then having this conversation called an interactive process, which is really just talking and figuring out, how do we solve this problem given a limitation you may have doing your job because of a medical condition or a disability, then finding that solution, and then most importantly, implementing that solution, having you do that reasonable accommodation. I'll give a quick example, so this is not in the abstract. I've had a client in the past who worked for a public employer. She was a librarian and she had type 1 diabetes. So she often had to check her blood sugar. I also think she had an insulin pump because it was that severe, so she had to regulate her blood sugar pretty regularly. And because of all the regulation and the testing and the monitoring, she asked for reasonable accommodations to do her job. She could do it, but she needed sometimes to come in later, or she might have to come in earlier and leave earlier. She might have to take frequent breaks during the day if something went awry with her blood sugar and she needed to take maybe a drink of apple juice or something else as opposed to medication like insulin. But the bottom line is she needed a change in her schedule, which is not a particularly major accommodation. And you'll find out that many reasonable accommodations don't cost much, and they really aren't significant disruptions to an employer's workplace. In this case, she made a request of her employer. She said, I have type 1 diabetes. I have this insulin pump. I have to frequently check my blood sugar. Sometimes I may go into a bit of a fugue state if my sugar's low and I have to do something. If it's really serious, I have an emergency phone number. I'd ask a colleague to call for someone to deal with this situation. Basically, they had a list of rules that would govern her employment and her schedule when she was there. But otherwise, she was fine because she regularly monitored her blood sugar and took care of her condition. That's an example of an employee who had a medical condition, in this case, diabetes. It affected her ability to do her job because she had to frequently take care of her blood sugar and monitor it. She didn't want to be in a condition where she might space out or God forbid, go into a diabetic coma if her blood sugar was really bad. And she managed to work out a schedule with her employer about when she could arrive, when she could leave, a number of 15-minute breaks during the day so she could either walk or eat snacks, and again, monitor her blood sugar. That, in a nutshell, is a reasonable accommodation, and it was worked out because she notified her employer. They spoke about it, they engaged in an interactive process, and they reached a conclusion how they would fix this problem. They then implemented it, and sure enough, it worked. She goes to work her regular hours. Sometimes they may be irregular, but she works the same amount of hours. And you had a mutual accommodation that didn't disrupt the workplace. Okay, so requesting a reasonable accommodation, step one, and there's an acronym here, FAIR, we use, is find the right person. So the first step is whether you work for a public employer or a private employer, you need to find the person in your HR department who deals with reasonable accommodations. Sometimes in a larger organization, they'll have an ADA coordinator. That same person will also handle LAD claims, right, law against discrimination, and they're familiar with reasonable accommodations in the process I'm describing to you. Sometimes in a smaller organization, they don't have individuals like that. You're going to have to find out who in HR is responsible for it. And the first step is finding that individual and in making sure that those individuals are the right ones that deal with these issues. If you have an employee handbook, consult that. Many times they'll mention who that is. It may just have a title, not a person, and then you have to find the person attached to that title. But once you find that person, that's the individual you're going to be making the request of. Now, when you ask for your accommodation and you find that right person, you want to put your accommodation in writing. It's best to use an email or an ordinary letter, correspondence, and you're basically going to ask for an accommodation, and you're going to let your employer know that you have some functional limitations. You don't necessarily have to spell out what your disability is in detail. You could call it a medical condition. You might describe it just as limitations. It's just enough to put them on notice. You don't even have to say, I'm seeking a reasonable accommodation. Since you're here present at this webinar, you might use those words, but the law doesn't require that. In plain English, you need to convey to them that, yes, in fact, I have some limitation doing my job, and I need assistance or an accommodation in order to perform the main job duties, the essential functions. But we strongly suggest that you do it in writing. You can make an oral request to your immediate supervisor or the applicable person in your HR department. But if you do that, I would strongly suggest you follow it up in email so your employer is firmly on notice of that. Okay, we've discussed plain English, doesn't have to be a reasonable accommodation verbiage. And we've talked a little bit about examples. I gave you the example of the woman who had diabetes. But it's important to give notice because you don't want to have a problem where you're either terminated or you're written up. And it turns out that a reasonable accommodation would have prevented those adverse things from happening to you. Once you do that, once you find the right person, right, and you've asked for an accommodation in writing, the next part is the interactive process. That's the I in FAIR. And that's the process where I call you're going to work it out. I won't even so much call it a negotiation as it's a conversation between you and your employer to identify what your limitations are functionally and what potential accommodations you're going to need to overcome those limitations. And it does require the law, both the ADA and the New Jersey law against discrimination, that both sides engage in a good faith effort to reach a reasonable accommodation. So we can fix this problem, much like the woman with the librarian with type 1 diabetes needed a change in her schedule, needed some frequent breaks to take care of monitoring blood sugar or taking snacks. The law requires a good faith action. If your employer says, I received a notice from HR, seems you have a problem doing your job, you're asking for an accommodation, the answer is no, I will not even discuss this with you. You either do your job or don't. That would likely be a violation of both the ADA, depending on how large the organization is, and likely, very likely, a violation of the New Jersey law against discrimination. So right now I'm going to take a pause because I've been talking for a while and ask if anyone has any questions thus far about either the ADA, the LAD, or the steps I'm going through about requesting a reasonable accommodation in the workplace.
Okay, so
Any
Charlie,
questions?
I'm going to ask a question.
Okay.
Okay, is every employer in New Jersey required to comply with the ADA regarding the provision of reasonable accommodations? And how does the ADA differ from the LAD in terms of employers' responsibilities?
It's a good question. The ADA applies, as I mentioned earlier, to those employers with 15 or more employees. It applies to public and private employment, so all forms of the federal government, state, and local. In New Jersey, it applies to one or more employees, so it's going to be a lot broader. I'd also mention that the New Jersey law against discrimination, because it's broader in defining the limitations that one is seeking to remedy, that is, you don't need a major life activity. Invariably, if you live or work in New Jersey, you're always best looking at the law against discrimination because it's just 180 degrees in terms of coverage. So that's a good question. And what I'd like to do now is ask if anyone else has any other questions, specifically about the practical steps now about requesting an accommodation, because that can be very daunting, going to an employer and asking for something that other people may not be asking for. So if anyone wants to share or ask questions, now might be a good time since we're getting into the details about reasonable accommodations. Any questions? Anything in the chat box? All right, we're going to move on.
Actually, Charlie, I have another question. And in terms of a new employer, can you talk about when a person applying for a job should discuss with the employer the need for an accommodation?
Sure. Again, we're talking about the same laws, but the process here is a little different. If you're going to interview for a job, some job postings, and I'll use a good example with the federal government, the state government also does this. In their job postings, they will say, we will provide reasonable accommodations if you need it as an applicant or a potential candidate. Some private employers do it, usually larger ones that have a fixed established HR department. And what you would do is if you're applying for that position, you can mention either in a cover letter or a separate document that you need some accommodations. It may be that you ambulate in a wheelchair or use something that's pretty basic or obvious. And I need to know that the building I'll be going to for the interview, assuming it's not on Zoom or Skype or something like that during our pandemic, the place is wheelchair accessible, that I can get in and out of the building, that there are ramps, that I can get into an elevator, that the doors in your office are wide enough to accommodate, a wheelchair. So that would be an example if you're an applicant. Nowadays, most things are done on Zoom because of the pandemic. So that makes things a lot easier for those people who might have a medical condition or disability regarding either their speech patterns or possibly if they're not deaf, they're hearing impaired. They would be able to tell their employer ahead of time, look, you may have to have captions for me in our Zoom meeting because I'm not going to be able to hear you. Even with hearing aids, I might have, say, a limited hearing, and I want to make sure I have a good interview. So you'd make those requests up front. And again, Good job postings will list that information. I know the federal government and state government are very good about listing it, and I'll have contact information about who to set that up with. If it's a public employer and they don't have it on their posting, then you may have to contact whatever information is on that posting with the local HR department and say, I'm going to need this accommodation. And I gave examples of some, but that's a good question. And people with disabilities sometimes are put off for applying for jobs they're otherwise qualified for, because they might think, well, as soon as they find out that I'm hearing impaired or I ambulate in a wheelchair, it's not going to happen. Well, that may be the case, and that would be discrimination if in fact that was the intent of the employer. But you have these rights. You can make these requests, and they're reasonable. That's why they're reasonable accommodations, and that's what they're called under the law, for an applicant to say, in order for me to successfully compete for this job, I'm going to need captions on my Zoom meeting or Skype interview, or I need to be able to go to the building if it's an in-person interview. So that's a good question, and I'd like to just encourage people not to be put off by it. You have rights, there's law that supports it, just do it respectfully and professionally. So I'm going to go back to the interactive process, and that's a process that you're going to sit down with your employer. In your original letter, putting the HR people on notice, you might even make suggestions about the accommodations that you need. And it might be, that I need to have, meetings captioned when we're on Zoom because I'm hearing impaired. That's a reasonable accommodation. Things may have to be written down for you if you have difficulty with an attention span or some cognitive impairment. You otherwise can do your job, but sometimes you might be forgetful. So it may be that meetings, staff meetings that you have in your office have to be recorded or written down or transcribed and provided to you so you can review them to make sure that any tasks that you were assigned, you recall, you now can do them, and you won't be forgetful and run into a problem down the road. It's really a collaborative process when we talk about interactivity. You're making suggestions to your employer says, well, I can or can't do this. Remember, the employer has a right to say, I can't provide an accommodation if it's an undue hardship. And we're going to talk about that in a little bit. But the interactive process is really where the rubber meets the road, where the problem solving goes on. As I just indicated earlier, you don't have to have the solutions. You're trying to work it out with your employer. I'm going to give a link at the very end for the Job Accommodation Network, which is a wonderful website everyone should use. It has great examples that deals with a variety of disabilities and medical conditions. They have a lot of self-advocacy materials, template letters to write, basically scripts to go through the interactive process, depending on what the nature of your functional limitation is. So I recommend that you do that. You may have to move a little quicker because I know we're running out of some time, but I want to make sure I cover some things for you. R, the last part of our acronym, reaching out to your employer to follow up on the request. Once you engage in that interactive process, the ball is in your employer's court. You have to obviously speak with them and engage with them, but they may just do nothing. That happens in some instances. The employer gets your request. They may ask for some medical records, which they're entitled to. But those records, by the way, even if they're requested, they have to be kept separate from your personnel file under the law. They have to be kept confidential on a need-to-know basis, maybe your immediate supervisor and someone in HR, but they can request documentation to prove you have a disability or functional limitation if it's not otherwise, clear. And an example I give is someone who has cerebral palsy who's ambulating in a wheelchair. At that point, it's evident. But for someone, say, who has a developmental disability or an intellectual disability, if it's not evident or they're not sure, they may request some information, but there's a limit to how much. It's kind of beyond the scope of this webinar, how intrusive they can be and your privacy rights, but they're entitled to some documentation to demonstrate you have a limitation. But once you've made the request, you've located that person, you've engaged in the interactive process, sometimes there's silence afterwards, and that could be that they're considering your request. If it's a large organization, they may have their own bureaucratic process internally, but don't let it go. You need to follow up. because otherwise the employer might assume that you've given up on the request, you've managed your own workaround, they've just decided they don't want to be bothered with it. Most requests for reasonable accommodations cost little or no money. If you go to the Job Accommodation Network, which will provide you the website, I think maybe Susan can put that in the chat box maybe as I talk about it. In addition to a wealth of self-advocacy resources, the Job Accommodation Network talks about going back to your employer, following up in a professional way and not letting it go. You may need to clarify what's going on with you. Certainly if it's affecting your job performance, you would think your supervisor or head employer is going to follow up on it because they want you to do their job and be productive in whatever your position is. But I recall from the Job Accommodation Network that the vast majority of reasonable accommodations either cost nothing or less than $500. There's a handful that may cost a few thousand. Again, it's beyond the scope of this webinar, but I will say that there are other sources employers can go to obtain funds to sometimes take care of and pay for the expenses associated with accommodations. But most really don't cost much at all, so the employer you're working for should be able to deal with it. The point is you need to follow up until you get an answer. Do it respectfully. You don't have to do it every day. You might wait a few days or a week or two. The goal is to work with your employer collaboratively to get the accommodation. So it's a win-win. You get to do your job, your employer gets a good, productive employee. And up there's the site here for the Job Accommodations Network. I know Susan will put it in the chat box. Wealth of information. I highly recommend people go to that site. I know I've given you a lot of information today. It's really a very broad area. Here's our contact information for Disability Rights New Jersey. I'd also like to thank the New Jersey Council on Developmental Disabilities. Here's their contact information. What I'd like to leave people with and then open it up to questions is that reasonable accommodations, there's a lot of law surrounding it. It can be complex, but the process for making a request, that FAIR acronym and the process I just outlined, is not difficult. It depends on your employer's response, and you're trying to work in good faith with them to solve a problem. That's what it's about, because you can otherwise do the job, but for some functional limitations due to a disability or condition. And as long as your employer makes those reasonable accommodations, because reasonableness is built into the standard, you can do your job and your employer has a productive, hardworking employee. So with that, I'm going to ask if there's any questions. I strongly encourage them. I'm sure there must be some out there because it's a daunting thing to tell your employer you're asking for something that others may not be asking for. So I'm opening up the floor to any questions.
So Charlie, there's a question from Carrie. What happens if I request an accommodation and my employer doesn't respond?
Okay, good question, Carrie. If they don't respond, make sure you found the right person, right? Double check if it went to the right person. If that person is in fact the correct one, follow up with a respectful email saying it's been X amount of days. I previously sent an email regarding a request for an accommodation. And then if you have to, CC either someone else in HR or CC your immediate supervisor. So this way people are put on notice. Remember, you don't want to be in a position where they say after the fact, when they've terminated you for poor performance, I never knew. And then there are 4 emails to 3 different people saying, I have this issue, can we sit and meet and talk about it? So you need to follow up. Now, if it gets to a point where there's just radio silence again, you can consult with Disability Rights New Jersey, call our intake unit, and we'll review what your facts of your case are. We can assign an advocate or an attorney to you. I'll quickly just say this because it's not something that we'd expect you to know about offhand. There's a state agency called the Division of Civil Rights, or DCR. They also handle complaints about lack of reasonable accommodations being provided. We've interacted with that agency on many occasions in the past. My suggestion would be, Carrie, to follow up. If after 2 or 3 emails, you either haven't heard a response where you've mailed them to people who you think are responsible in the organization, certainly your immediate supervisor would be, and you're just not getting any response, I'd contact Disability Rights New Jersey, call our intake unit. I know I flashed our website and contact information up there. Maybe Susie can put that in the chat box again. Speak to our intake unit. They'll take all your relevant information about the narrative facts of your case, and we'll have an advocate or an attorney speak with you, and we'll brainstorm about what to do next. It might be filing a complaint with DCR. You might be contacting the employer directly. There are all sorts of things we can do, but don't let it go, especially if it affects your job performance. Any other questions?
It wasn't a question necessarily, it was a comment.
Yes.
So I'm working with a student who needs accommodations to complete applications, and he doesn't have the confidence to ask for the accommodation. So he doesn't apply. He is slowly building up his advocacy skills, and I will share FAIR with him.
Good. Thanks for that comment, Kelly. You know, a lot of times, as I mentioned, people are fearful or anxious justifiably, whether it's as a result of their condition or just being an employee in these really difficult circumstances we find ourselves in, even pre-pandemic. You know, it takes a hardy person. It takes courage to go to an employer and say, I'm having difficulty. I mentioned I had an employee who developed MS, and this person was a very bright, well-educated person, and it was a really shocking diagnosis. And as it became manifest, you know, he started tripping and falling, and people noticed. He was fearful. He said, I think they'll terminate me. And I said, well, if you don't tell them and ask for an accommodation, you know, if they decide they're going to terminate you, it's unlawful, you might have a legal remedy. If you say nothing and they terminate you, you're going to be hard pressed to explain why you didn't say anything, because the law gives you these rights. That's why we call this know your rights, and you need to exercise them respectfully and professionally, but you need to put people on notice at the appropriate circumstance. So Kelly, thank you for that comment.
And just a really quick follow-up on Jan, the link for the Jan site is in the chat box. As Charlie has indicated, this is a fantastic service for anybody who is thinking about requesting a reasonable accommodation. It's a really expert service. You can email them, phone them, live chat with Jan. They have experts in every type of disability you can think of, and you can speak with these experts and have a conversation with them about possible accommodations that you would like to discuss with your employer.
And I'm just going to
I'm sorry, Charles. Go ahead. It looks like we have another question in the.
I saw that.
Okay, great. So
it says the question is
period for an employer to respond after the request.
Yeah, we're not talking about a lawsuit and the statute of limitations, because that can happen in some of these instances, but just in terms of ordinary life. Once you make a request to your employer, there is no specific limit other than reasonableness, which some people might, disagree with. But depending on the nature of the accommodation or the limitation, you would expect your employer to respond within a short amount of time. It might be a day, it might be a few days. Again, if you're a new employee, I would certainly raise these issues up front if you think it's going to be difficult. If it's an acquired disability or condition that's happened to you, your employment may be dependent on your doing this, because if it affects your productivity, you're better off doing it quickly. But to answer the question, there is no 5 days or 10 days that your employer has to respond to the request. It's a reasonable amount of time. They do have to engage with you as a matter of law, which is what I was referencing earlier. They just can't ignore you and let things proceed apace. So that's the short answer to that question.
Great, thank you so much.
Okay.
And it looks like we are just about out of time right now. And I don't see any other questions. Barb Coppins wanted to say thank you to Susan and Charlie.
Thank you, Barb.
Employment, awesome job. And yes, and I too want to thank the two of you. And I appreciate everyone who participated today. And thank you, and have a good rest of the day.
Thank you.
Bye, everyone.
Bye.